Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia, with offices in Woodstock, Cumming, Jonesboro, and Dunwoody. I'm here to talk to you today about whether you can prefer or make payments to family members before you file bankruptcy. First, I want to issue this disclaimer. We're a debt relief agency proudly assisting consumers in filing bankruptcy under the United States Bankruptcy Code. Uh, However, there is no attorney-client relationship with the viewer of this message. I would have to meet with you individually to offer you applicable and accurate legal advice. So today's topic is, can you pay money to family members before you file? Well, basically what this is can you prefer family members? The legal term would be a preference. As a general rule, that's going to be no, but it is going to be fact specific. Let's say you give your sister $4,000 before you file, the month before you file. Well, as a general rule, that's going to be a big no-no. However, the question is, did you give it to her as a gift? Was it to evade having that much money in your account because you thought maybe you'd lose it to your trustee before you filed bankruptcy? Did you owe your sister money? She gave you a loan at some point and you're on a repayment schedule. Did you, or maybe your sister has a secured right in your collateral, meaning you bought a car from your sister, so your sister's a secured creditor. Well, payments in the ordinary course of business to secured creditors are not problematic. Payments of just gifts to people on the eve of filing are absolutely problematic. Not only can the trustee rescind those transfers under what are called avoidance powers after your bankruptcy is filed and recoup the money from your family member, but depending on the nature of the transaction as well as the disclosure of it on your petition, you also could be denied a discharge, and not just a discharge of, say, your debt to your sister, if that was why you made the payment, a discharge of all your debts. There are certain code sections that could apply that could deny you a total discharge of your debts. So if you give $500 to your sister right before you filed, it actually could be okay. Like I said, the car loan example, but and particularly if that's just the average, the monthly payment according to the note. You've been paying your sister $500 a month for that car loan for the last 24 months, and the reason you got that car loan from her was because you could not get credit. You were a bad credit risk. No one else would give you a car loan. You needed it to get to and from work. And your sister properly perfected her interest as a secured creditor, meaning she didn't just say you two didn't just say, oh, well, if I don't pay, you can take my car back. There was actually a proper recording of her secured rights in the state records. So if that's the case, she's a secured creditor and that payment's okay. If, even though you intended for her to be secured, there was never a perfection of the secured rights, and she was therefore an unsecured creditor. Now, you chose to pay her $500 while you told American Express, I'm not going to pay you anything, or you told Chase or Visa, I'm not going to pay you anything. So you have, you took among 4 unsecured creditors, you pick one who happened to be your family member, and you preferred that person, your sister, as the creditor. That is a preference. Any payments over $600 to creditors in the 90 days before filing to any creditor, even if that money had gone to American Express, can be rescinded as a preference. But the look-back period for a payment to a family member is a year. So in this instance, if your sister was unsecured and you paid her $500 a month while ignoring all those other creditors, you preferred her for a year at $500 a month, that's $6,000. After your bankruptcy is filed, your trustee can recoup the money. Now they have to go after your sister, but your trustee could recoup the money from your sister And again, if that was something you didn't disclose, um, then you could potentially be denied a discharge. Now, if you disclosed it, your sister might have adequate defenses. It might be in the what we call the ordinary course of business. Um, you might have also been paying your other creditors at the same time and at the same maybe pro rata amount, and therefore it wasn't really a preference. But that's, again, fact specific. But the general rule is if you're paying money to family members or friends as you get closer to filing and they're not secured, it certainly has the potential to be problematic in your bankruptcy case. And again, that's true whether it's just a different analysis, whether you owed them money or whether you didn't owe money and you were just making a gift. It's a longer look back and potentially worse if it's just a gift. Whereas at least if it's a family member you owe money to, the look back period's shorter and essentially the intent is less frowned upon.